The Evans Law Group, providing a full spectrum of family law services.
It's more and more in sort of our mobile society, it's very common to get parents who come to me with questions about how to transfer cases or about jurisdiction, because either the prior orders or decree or custody orders were established in a different state, and the kids and or the parent or a parent have moved to Austin, Texas, or our area, and they're looking to modify those orders. It's a question of how do you do that if the orders were established either out of state or, and now you have the parents and the child that's living here in Texas. That is, if there are kids involved and there are prior orders, that is governed exclusively by a statute that's known as UCCJEA. Those are the initials for the Uniform Child Custody Jurisdiction and Enforcement Act. If you go Google that, you'll find that every state in the United States has adopted the UCCJEA as a uniform act across the country, so that there's parity or uniformity among all the states about how to deal with that question. In other words, which state has the power or the jurisdiction to determine the rights and the duties of, and all the issues related to that with the kids. And the basic analysis is this. You start with what, you have to figure out first what's known as the home state jurisdiction. And in your Google searches, you'll see this, and on my website at evansfamilylaw.com, you'll see articles about this. The home state jurisdiction is the state that the child has lived in primarily for 6 months or better, or if the child is under 6 months of age, like an infant, wherever the child is living, or it's the state where the prior orders were rendered. So if, for example, we have a couple that was divorced in California and they got custody orders and divorce and the decree and everything is done in California, and then the mom and the kids have moved to Texas, the first question out of the gate is how long have the mom and the children lived in Texas, and does Texas acquire jurisdiction over those kids? There's lots and lots of exceptions and nuances to the UCCJEA, but if the parents, for example, in that case, the mom and the child have been living in Texas for less than 6 months, then Texas, generally speaking, would not have jurisdiction to modify that order out of California. If the mom and the child or the kids have been living in Texas for more than 6 months, then, and you have a situation where the prior orders were rendered in California, and if the other parent still resides in that jurisdiction, okay, so dad, in my hypothetical, still lives in the county in the state of California, and mom and the kids now live here, what ends up happening in that situation is it becomes sort of what I call a jurisdictional jump ball. Because then what happens is Texas has the ability to accept or acquire jurisdiction. The parent here would then file their modification, would file a registration of the orders out of California and provide notice to the courts here in Texas that we have a foreign order from a different state. And then the courts here would get into an analysis between the courts here and the courts in California, and they would talk. They're required under the UCCJEA then to have sort of this judicial conference call where then they compare all of the touches, is what I call it, of the kids and the mom in Texas and all of the touches to California, and the states then determine, based on what the issues are being presented to the court, which state is better to have jurisdiction. Is it Texas? Is it California? And it depends on many, many factors. You know, what specifically are the issues for modification? For example, an easy one is if it's just child support, California may just keep it out there in California because that's just a money issue. If you have a kid that has special needs and there's lots of doctors and therapists and counselors involved or something, and that's been going on a while here in Texas, and all those witnesses and those records and things are available here in Texas, well then Texas may have a more significant interest in acquiring jurisdiction and hearing the case here in Texas. But nevertheless, the courts will conference between them and decide which state then acquires the jurisdiction. Texas then would have the option to decline the jurisdiction, or California would have the option to decline the jurisdiction. And then whichever state then accepts jurisdiction is the state that can then move forward and consider the modification.
When life's path takes an unplanned turn, call the Evans Law Group for a consultation at 512-628-2550. The Evans Law Group, providing a full spectrum of family law services.